Hello, everyone. Welcome to Ask the Expert. I'm Kathy Johnston Pittman, the CAMS Director of Professional Development. CAMS is an association management company that was founded in 1991, and we work very hard to provide trusted guidance to our clients, to the boards that we serve, the members that we serve, and as part of that, we host these monthly webinars. Today's topic is cocktails, case law, and corporate rentals. Some interesting topics will be covered by our experts today, who are Tim Sellers and Steve Sellers, who between them have over 50 years of association law experience. They are with Sellers, Ayers, Dortch, and Lyons law firm, and we are thrilled to have you present your expertise to us today. Tim and Steve have a presentation for us, and at the conclusion of that, we will answer questions that you may ask by putting them in the Q&A function of our Zoom meeting. So, welcome everyone again, and welcome Tim and Steve. We look forward to hearing what you have to say, and we'll turn it over to you.
Thank you.
Okay, thank you very much. We're going to have a technical shift here. As Kathy is going to stop sharing her screen, and now I have the pleasure of trying to technically share mine. Let me see if I can do that with some. Okay, how did that go?
Perfect.
Okay, great. Well, we are delighted that you joined us today for this, you call it Ask the Experts. We call it the CAMS Summer Law Seminar of 2022. But we're happy to be here to share with you some of the many developments that have occurred over the past year. And so that's our job. Your job is just to relax because your workday is over. It's 5 o'clock. If you have one, pick up your drink of choice, and we will make our way through many of the things that have happened both in North Carolina and in South Carolina over the past year that may affect you and your community. Things that you need to be aware of if you're going to serve your community well. But we have a question for you first. Tell me what just happened here, and I have some choices for you. You can look at the picture there. The first choice is that these board members just adjourned their annual meeting, where the members approved a 15% increase in annual assessments and a $250,000 special assessment to replace the roofs. Now, that's not the only option. Here's a second option. After working together very closely for the past 3 years, the association's president and its ACC chair in the center just announced their engagement. See the happy couple there? Or it could be that these board members just got their lives back when they were voted out of office at a contentious special meeting and replaced with new directors who are sure that they can do a lot better. Or none of the above. And while we're talking, you can insert your own answer to this question in the chat box. We'll come back to this at the very end. In the meantime, we're going to talk about 2021 and 2022. COVID-19 continued wreaking havoc on associations. In North Carolina, we had the advent of statutorily authorized remote meetings, as well as some very intense legislative action, which we will mention throughout the presentation as it relates to the cases we share. Not much in South Carolina, so you South Carolina folks, you can relax a little bit, but there were several different important court decisions. In fact, there were so many that Steve and I had to cut at least 4 or 5 out and choose the ones that we're going to share today. And we have a lot to share before we open it up with questions. So let's get right to it. You're going to note that our cases are color-coded. And I was trying my best to find a color that would approximate Gamecock burgundy. I may be a little off here, and so I'll extend my apologies also to the Clemson Tiger fans who would have preferred orange, but I had to make a choice. So when you see this color, we're talking about a South Carolina case. The North Carolina cases will be blue. One of the things that you'll notice about the South Carolina cases is that they're all unpublished, which seems to be the way they do it in South Carolina. These cases are deemed to be so fact specific that the courts of appeal, the Court of Appeals in the Supreme Court in South Carolina, decide not to publish the case so it doesn't have any preferential value. But it still tells us what the courts in South Carolina are thinking. And Griffin versus Arden Chase is an unpublished decision dealing with, guess what? Yes, an architectural issue surrounding a 24-foot high garage for an RV. The Griffins asked the ACC to approve it. And the ACC said, no, we're not going to approve it. Well, the Griffins, as sometimes happens, went ahead anyway, started building the detached garage. Now, the restrictions in Arden Chase prohibit garages that with an opening to the roadway in front of the residence. At trial, the court found that this garage was in violation because it faced the right-of-way of the street in front of the house. Okay. So the Griffins changed the door. They didn't turn the structure. They, everybody finds a way to try and find a loophole. They just twisted the door around and said, well, now the door is facing over here and doesn't face the roadway anymore. Well, the ACC said, you're not going to fool us that way. Rejected it again. The fight ensued again with the association asking for an order to tear the thing down. And the Griffins saying, not so. We want approval. Further, we want a finding that the actions of this ACC and this association were improper, unjustifiable, arbitrary, malicious, and every other ugly word they could think of. So what did the Court of Appeals do? Well, the Court of Appeals, interestingly enough, said, roadway, right-of-way, street, highway, words have meaning. And in South Carolina, a roadway is the portion of the highway that is improved for vehicular travel, not the shoulders of the berms. So it's not the entire right-of-way. Street, highway, those kinds of words include the right-of-way. Roadway means just the pavement. But they also said an unreasonable rejection or disapproval of a reasonable plan in South Carolina is actionable. And the Griffins are entitled to pursue that claim. So they sent the case back to the trial court for a further ruling on the roadway versus right-of-way situation and possibly liability on the part of the association and the ACC. So what are the takeaways? The exact words and restrictions matter. Don't assume words that appear to be similar mean the same thing. And remember that courts are duty-bound to interpret restrictions to allow free use if there is any uncertainty. And then, notably, here's a court that said an unreasonable rejection of a reasonable plan is actionable in South Carolina. Steve, let's go to North Carolina.
Take us to North Carolina with Belmont versus Farwig. This is decided in May of 2021. It's the North Carolina Court of Appeals case. Honestly, as we go through this, I think you'll see what I mean when I say it's a case that I'm always surprised to see that things like this actually have to go from the judge, because the ultimate result in this case is that the statute that we're going to talk about here in a moment means exactly what it says, which seems to me like you wouldn't need a judge to tell you that, but the Farwigs felt differently. Briefly, the facts of this case, again, architectural matter, this time dealing with solar panels in North Carolina. Farwigs bought their home subject to a declaration that was recorded in 2011. In 2018, Tim, if you can advance my slide for me.
Sure, sorry.
That's fine. In 2018, they installed a street-facing solar panel on their roof without approval, submitted a late application that was not surprisingly denied. HOA ordered removal. Everybody got angry. Litigation ensued, and we're all of a sudden in court. The Farwigs argued that the North Carolina solar law, and I'm going to talk about how this law might be changed in the near future, but as of the date of this case, 22B20 in North Carolina, Farwigs argued it protected them because their rear-facing panels would be inefficient, prohibit the reasonable use of the solar panels on their homes. The court decided that 22B20 does apply, no surprise there at all. The statute permits the association to prohibit the location of solar collectors that are visible to a person on the ground and mounted on a roof like theirs that sloped down towards an area that was open to common or public access, even if doing so prevented the reasonable use of solar on the property. So that the association under this law as it exists today could say you cannot have a solar panel on this front facing sloped roof of your home, even if that means you can't have solar access on your property. And the court's decision turned on reading the statute exactly as it's written in the order that it's written. And I'm going to, the next slide when Tim goes to, it's going to show you a lot of text. Don't freak out. These are two subsections that were relevant to this decision. I'm just going to draw your attention in subsection C up here, where it talks about the association being able to regulate location and screening, provided, see the underlined portion here, that the deed restriction does not have the effect of preventing the reasonable use of a solar collector. This is what the Farwigs were relying on, subsection C, because it talks about reasonable use. However, if you go down to subsection D, you're going to see that there are these three areas, 1, 2, and 3 there, where an association right now has very broad authority to prohibit solar panels, even if it means you can't have solar anywhere else on the property. The thing that I find in my practice, and I think Tim would agree with this, is we very often get letters from attorneys who are representing, supposedly they're representing the owners who are putting these applications in front of the ACC. Really, when you dig into it, they're hired by and representing the solar installation companies. And a lot of times these lawyers will make this same kind of argument that Farwigs did. And they're just misreading the statute as it exists today. So my takeaways here, number one, read the law. And if you have questions about what the law means, call your lawyer. That's what we're here for. Don't be intimidated, though, by letters that your association might receive, like the ones that I described from an attorney, like the attorney that was representing the Farwigs, saying that you can't do this or that under 22B20. Almost every one of those letters that I've ever seen misapplies the statute in exactly the same way that the Farwigs did, and in exactly the same way that the North Carolina Court of Appeals said did not fly. With that said, there was last year, and it's a renewed effort in the legislature to change that law and to change it in a way that would greatly strengthen the homeowners' rights in terms of access to solar power on their properties. I've actually got the text of Senate Bill 826. This was just introduced at the end of last month. This is not the law yet, may never become the law, and may become the law in some other form than what I'm going to tell you right now. But this is what's out there right at this moment for consideration. And the big changes, as near as I can tell in this law, are number one, it strikes subsection D entirely. If you were to go back and look at the slide previous, that's the one that essentially allowed this association to do what it did, prohibit solar panel. That subsection, if this was passed into law, would go away entirely. And then in addition to that, it would strengthen the language in subsection C to where essentially you could regulate the location and screening of solar collectors, provided that you don't reduce the operating efficiency of the solar collector and solar panel. And that's the statute would then go on to define that as a 10% reduction in efficiency. So if this is passed in any kind of form like it's in right now, the law is going to be very, very different at that time. So we're just going to have to keep watching that and see what happens with it. But the decision in the Farwig case is consistent with what the law is as I speak to you today.
Okay. Before we go on to that, Steve, as you know, I serve on the North Carolina Legislative Action Committee. The good thing about that particular bill, the Senate bill Steve referenced, is that it was referred to the Rules Committee for action. And sometimes the Rules Committee is also referred to as the black hole of the legislature. And so it may go in there and never come out, but it is an active piece of legislation. And so we have to be sensitive to it, even if we don't like it. Speaking of not liking it, this is a ridiculous case called Executive Office Park versus Rock. It is bad law, but it is still the law. And what it deals with, this is a condominium. And so what we were talking about is whether the condominium association had the authority to foreclose under a power of sale. Power of sale meaning the abbreviated proceeding that we have in North Carolina to allow for foreclosure. South Carolina folks, you don't have that. It's judicial, so don't worry about this thing. We're the only ones up here in North Carolina and our associations here that have to worry about it. So 47C is the new Condominium Act, and the new Condominium Act has a provision in it that's on the screen now that talks about Section 3.116 applying to all condominiums created in the state on or before October 1, 1986, unless the declaration expressly provides to the contrary. Well, the judge in the Court of Appeals, or his law clerk, whoever did this, decided that in this case, this was a 1982 declaration. Well, that's 4 years before the Condominium Act was passed. And so it provided that it would be governed by the 1963 Unit Ownership Act. It was the only act under which a condominium could be created. So that was an irrelevant fact. And they also pointed out that the Unit Ownership Act does not provide for a non-judicial power of sale foreclosure. Of course it didn't. That's one of the reasons the Condominium Act was adopted in 1986, was to create that. And they further noted that the declaration didn't provide for a non-judicial power of sale foreclosure. Again, not a surprise because it wasn't authorized at all until the Condominium Act was passed, and the declaration was not amended to make 47C3.116 applicable. Again, not a surprise since the statute itself said it was applicable. So we have a court decision saying that there is no power of sale right in condominiums, pre-86 condominiums, and that's a problem. But it's not over till it's over. And the Supreme Court decided to review this case, and that's still out there. But even more importantly, and this is an update, as of today, Senate Bill 278 has been amended to include revisions to both the Unit Ownership Act and the Condominium Act that will legislatively reverse this case. And this should pass in this 2022 short session. I've got a note there that please thank the North Carolina CAI LAC. The LAC committee worked extensively on drafting these revisions and getting them before the legislature through our lobbyists. And it went in one bill, but we had to shift it to another because that's how the legislature works sometimes. So potentially a very good result to a very, very bad case. The takeaways, in this case, in all cases, bad law is still law until it's not. No legal position is guaranteed. In this case, we're about, hopefully, to reverse this bad decision. And I also want to put in a plug to support the Legislative Action Committee, which was instrumental in getting these changes to overturn a ridiculous decision, in our humble opinion. Steve, tell us about Davis versus Lake Junaluska Assembly.
Another North Carolina case. This one also, like the last one I talked to you about, has a whole lot to do with statutory interpretation, which reading the law and applying it. This was decided in January 2022. Briefly, some facts on this case. The Davises purchased their lot in 2011, buying into a very old community. That picture that I showed you up front is actually this community, so it's very old, but apparently very nice. Formed in 1913. Davises, shortly after moving in, are less than thrilled with what the Assembly is doing. The Assembly is their association. Davis has filed suit alleging that the Assembly had violated various provisions of the North Carolina Plan Community Act. That's Chapter 47F. Tim was just talking about Chapter 47C with condos. The claims that the Davises were making had to do with the disclosure of financial records, how amendments were adopted, how the Assembly was leaning properties and collecting unpaid assessments, things of that nature. The key point being that all of those issues were addressed both in the Assembly Charter and in 47F, in the Planned Community Act. Essentially, the Assembly had complied with its own charter document, which is like its Declaration of Covenants, its CCRs, but had not complied with what 47F said on those particular issues. So the question becomes, does the planned community apply to this old community? If so, how much of the act applies? And then a third question that I don't have on my slide here is, if the act does apply, or a portion of it does, how does that interface or impact the validity of a pre-existing declaration? And that's ultimately what the case turned on. The Assembly itself, as I said, was formed well prior to 1999, which is the effective date of the Planned Community Act. So it's obvious from the start that the entirety of the act doesn't apply. However, there are about a dozen or so provisions in the Act that apply to all planned communities created in North Carolina, even those created before 1999, unless the Articles of Incorporation or the Declaration expressly provides to the contrary, which of course it won't, because you can't have a declaration prior to a statute that references that statute and says the statute doesn't apply. So again, you wonder what the legislators were thinking when they wrote that particular part of the statute, but there it is. The provisions that apply, I'll say retroactively, to all North Carolina planned communities are these. And I've got some bold sections there just to call your attention to some of the issues that are raised. Like, don't bog yourself down and looking at this. If you ever need to refer to it, it's there for you if you need it. Essentially, all of those provisions, even when they do apply to a pre-1999 planned community, do not invalidate existing provisions of the Declaration. What that means is that, yes, these provisions apply to an older community in North Carolina. But if there are contrary provisions in that older community's declaration, those control. So there's several layers of analysis that you've got to go through, and that's Tim's job, that's my job as your lawyer, but it's also helpful, I think, for you as board members to be aware that that's how the Act is going to apply. There's a similar analysis for a condominium under 47C, not identical, but very, very similar. And the main takeaways that I think Tim and I want you to walk away from this case with is that you not get caught thinking that 47F has absolutely no applicability to your older community just because you were formed before 1999. That's not true. On the other hand, don't just blindly defer to the Act either. If you've got a set of documents that predate the Act, we've got to look at how those potentially mesh with or conflict with provisions in the Act, and then we've got to make a call on which one applies. Again, that's a legal determination that Tim and I are here to help you make, but you do need to be aware of that so you understand how this very important statute applies to your community, even if you were formed before its effective date. So that will take us away from statutory construction, Tim, and I think we start getting into Marketable Title Act.
Well, we do. And of course, that's another statute, and we're in North Carolina. As you'll see, we still have the blue color here. And this is C Investments 2 LLC versus Auger, actually decided in May of 2021, issued the same day as the Rock case. This is a case that has created tremendous concern because it interprets a statute in North Carolina called the Marketable Title Act, which was adopted in the 1970s. Well, you know, there weren't a lot of planned communities around then. There were some, but the Planned Community Act wasn't adopted until 1999, which the new Condominium Act was 1986. We're talking about 16 years before the Condominium Act. And what the Marketable Title Act says is basically any person who has title to property, and that means themselves and those who were their predecessors in title, people who owned it before them, for a period of 30 years shall have marketable title. And basically that, except for some limited specific exceptions, anything that was on the title before that 30-year period is null and void. So, I mean, consider that. They wipe the title clean if 30 years have passed. Well, we do have now a lot of planned communities that are older than 30 years. So what happens to them? Well, there is an exception in number 13 that talk about not wiping out covenants that are applicable to a general or uniform scheme of development, which restrict the property to residential use only. Now, what happened is that this association took the position that, well, we're a residential community, so our covenants are not voided. The Augers, and in fact, there were two other cases, companion cases, right alongside this, who took the position about, oh, no. That just means only the covenant that says residential use of lots only survives. Everything else, building setbacks, architectural control, everything else goes out the window. And they cited this red language at the bottom that said restricted covenants, other than those mentioned here, are not accepted from the provisions of 47B. So there was a lot of arguing about that. The trial court found that they did, and it went to the Court of Appeals. And basically, here's what they said. Simply put, we reject the defendant's invitation to trek into the minds of the legislature and rewrite the statute. It is clear and unambiguous. Under the statute, covenants that survive are those applicable to a general and uniform scheme of development that restricts the property to multifamily or single-family residential use, or simply residential use. And this, they said this in the opinion. That's it. Anything else is gone. So we have the potential for covenants on 30-year-old communities to be completely wiped out simply because of the passage of time. There is a provision where you could extend them, but you have to go through a process to do that, and you have to do it before the 30 years passes. Well, there are a lot of communities that were more than 30 years old, and of course hadn't done that because this interpretation of the statute had not come down. So, good news again. In fact, maybe even better news than as good a news as I gave you in Rock. It's not over till it's over here, and the Supreme Court did agree to review the decision of the Court of Appeals, but better yet, again, today I got word that Senate Bill 278 has been amended to expand exception 13 in 47B3 to exempt declarations covering most condominiums and planned communities. And we do, it's in the House now, it's going to come back to the Senate. We do expect that to pass in the short session. So when we first started talking about this case, it was a bad case about which we were very concerned for our clients who had old covenants. Now we're very hopeful. And the takeaways are, remember that frequently updates to the law and revisions to it run behind the time. They don't keep up with changes or decisions. If 278 does not pass, and we believe and hope that it will soon, and your covenants are close to 30 years old, you may consider extending them, and that's under section B4 of the statute. You'll need to talk to your lawyer. And again, I'll make another plug. The actual text to this amendment that we hope will pass in the next few days was developed again by the NC Legislative Action Committee, working together with the title attorneys and the real estate attorneys in the state to try and find a solution to this very troubling opinion, which hopefully will be a matter of history very shortly. Steve, Benson versus Prevost.
Prevost. Yep. This is a case about easements and boat slips, and I don't have a facts slide for this one because I think it's helpful as I talk about the facts a little bit for you all to be able to continue looking at this overhead diagram of the actual easement area that we're talking about. The parties in this case, Benson and Prevost, are the next door neighbors in a 3-lot subdivision in Wrightsville Beach. The Prevost own lot 2. Their deed gives them the right to use a driveway easement over lot 1 that was owned by the Bensons. And it also gives them the right to use one of 3 boat slips in this community, slip C. The Prevost thought when they bought their property that they were getting slip A, not slip C, which is what's in their deed. And that matters because slip A features a boat lift and slip C does not. So again, just to get those facts clear, they entered into a contract with the developer of this community. There's essentially their sales contract said, you're going to get the slip with the boat lift in. The deed that was actually recorded did not reflect that, gave them the other slip, the less desirable slip. The Bensons purchased their lot 1 year later and take a deed giving them the right to use slip A. So the Benson's deed actually includes slip A, which is, again, the better one. Obviously, trouble ensued when the Prevost. It's difficult to tell reading the case. It sounds like these folks kind of got along and made it work for a little while, but then somebody did something to really irritate one of the other ones, and they started fighting over everything they could think to fight over. So they started fighting over this easement, started fighting over the boat slip, and that's how this case came to be. In the end, though, the trial court determined that the Prevost could lawfully park on the driveway easement in addition to using it to physically access their property. And the trial court also determined that the Prevosts were the lawful owners of slip A, even though their deed gave them slip C. So that's what the trial court decided. It's kind of a crazy result. I see Tim's reaction to it. It's a crazy result. We'll go on to the next slide because I'm going to talk about the easement decision first in the Court of Appeals and then talk about the boat slips. The easement decision that the trial court made was affirmed by this Court of Appeals. They agreed with it. The reason that that they did was there was no express statement in any map or any document describing what this driveway easement was going to be used for other than a driveway. So there's no guidance or limitations put in any map or document to tell these folks what they can or can't do. That puts the court in a position of having to make a decision about what is the reasonable use of the driveway easement. So the court goes through all this analysis of determining what without the express terms being provided, what's reasonable with an easement like this. And ultimately, the third bullet point there, the court decided that the creation of a driveway easement that's 20 feet wide to be used by the owner of a vacation home, where the easement is close to the home, suggests an intent that the driveway also be used to park and not just to access. So the point being, the court's looking at all these facts to try and piece together what can and can't lawfully happen in this easement, rather than the parties just taking the time at the outset to spell it out to where there's no confusion at all and no room to argue. That's going to be one of the, I think, the takeaways that we have on the easement issue. That is, your association. I'm going a little bit out of order, Tim. Don't worry about my slides.
Good.
Yeah, it's okay. Your association may at some point be asked to either grant an easement. You may need an easement from somebody who owns property adjacent to your association. Either way, for goodness sake, take the time on the front end rather than just signing an easement document that gets put in front of you. Take the time to specify what's going to be allowed and what's not. Because if you don't, you're going to find yourself in the position of these folks where you're at the mercy of a court making that decision for you. And that's not the place you want to be when you have the option of determining your own destiny up front. That's what you want to do. And I think that's the key takeaway on the easement issue. The boat slip issue is a little interesting to me. The Court of Appeals reversed the trial court. You remember the trial court essentially said to the Prevost, yeah, you get the better slip. We know it's not in your deed, but you thought you were getting it. It's reasonable that you thought you were getting it, so you can have it. Court of Appeals said that's not going to fly. In North Carolina, the recorded deeds control the outcome in the order of their recording. Those recorded deeds override any contrary expectation that was set by anything in a purchase contract or anything that the developer told these folks when they bought their properties. In the end, the Bensons walk away with a better boat slip that has that boat lift in it because it's in their deed. The court, though, kind of went out of its way, I think, to emphasize that the result might have been very different if the Prevost had filed a lawsuit over that mix-up that they knew about. You remember I said they kind of got along for a while and had worked it out until somebody got irritated about some other thing, and then it blew up into a lawsuit. The Prevost had an opportunity to file a lawsuit and ask a court to essentially reform the deeds, is what it would have been. And if they had done that before the Bensons purchased their property, like as soon as they knew there was an issue, if they had done it, they, in all likelihood, might have been successful in getting their deed reformed to reflect the fact that they were getting the better slip that they thought they were getting. The takeaway here is that they lost not because they didn't have a legitimate claim, but because they slept on their rights. They didn't act when they had an opportunity to act. And I think that's the takeaway that I would emphasize for you all. If you find yourself in a position, whether it has something to do with the boat slip or not, if you find yourself in a position where there's a right that you need to assert that right and don't wait, because you can lose the opportunity just like the Prevost did here. So interesting case there, I think. Tim, I think you're taking us back to South Carolina with Braselton v. Roberts.
Yeah, we are going to go back to South Carolina. We're moving back and forth, South Carolina and North Carolina, just as Steve, you and I do every day with our clients that are in both states because we're licensed in both states, as is Brett Dressler and Cynthia Jones in our office. So this is sort of a daily occurrence for us, going back and forth among the different principles that apply across the state lines. Here again, you see an unpublished case from the South Carolina Court of Appeals, and in the Roberts case, and it involved, the subdivision had 5 lots in it, much like this, and they were noted as lot C1, C2 through C5. And you'll see that little highlighted notation on there. There were some other notations on the map, but this is the one that was key. It said exactly what you see right there. So just take a look at that for a minute and you decide what that means. Okay, well, here's what happened. A community map was filed with that notation on it. The Braseltons bought the lot that was not mentioned, C1. And they sued their neighbors to prevent them from building homes because their lots were unambiguously restricted to agricultural use only, right? It's on the map. It's on the recorded map that was referenced in all the deeds. But interestingly, this notation was not placed on the map by the developer owner. It was placed on the map by Charleston County. The government put it on there. In fact, the developer owner said, and the surveyor said, well, wait a minute, that wasn't our intent to restrict the use of the property. It was just to warn lot buyers that there were issues with the sewage disposal services. Now, you go back and look at that. We might have chosen better language to say that there are issues with the sewer disposal services, like maybe, hey, there are issues with the sewer disposal services on C1, C2, C3, and so forth. But the county just puts this one on there. The Braseltons argued that the language is plain and ambiguous, and that outside evidence of a contrary intent was improper, meaning having the developer come back and say, oh, I didn't mean that. We can't do that. Seems pretty straightforward to me. Surprise. The trial court said it was not a valid restriction, and the Court of Appeals affirmed. The reason is that restrictions, again, we mentioned this earlier, must be strictly interpreted and all doubts resolved in favor of free use. Now, honestly, it doesn't look to me like there's a whole lot of doubt about what that says. But the court noted that the paramount rule of interpretation is to give effect to the party's intent based on the document as a whole. And if it is ambiguous, outside evidence of intent is allowed. The developer, the surveyor can say, we didn't intend that, it was Charleston County. And here they said, while the language is not ambiguous, hard to say it is, the origin of the language created an ambiguity, authorizing the developer to testify as to intent. And he did, and he said, I didn't intend it. And that's what the court found. A surprise to the purchaser of lot C1. So the takeaway, don't forget, again, and we emphasize this over and over because so many times our clients are surprised. Land use restrictions in South Carolina as well as North Carolina are not favored and must be created in express terms or by plain and unmistakable implication. If there is uncertainty or doubt, and a restriction may be interpreted in 2 or more ways, the court, by law, is obligated to adopt the least restrictive interpretation. And appellate courts give lots of quarter and benefit of the doubt to trial courts who do that. So be aware, you can get surprised, as I'm sure the plaintiff was in this case. See, we got another South Carolina case, don't we?
South Carolina case, Homestead case versus Miller. I read this as a cautionary tale about foreclosures in South Carolina.
It is.
The facts of this case generally are that the Millers own a home which they purchased for right around $230,000. Somewhere along the line, they failed to pay a $180 annual assessment. Their HOA filed a lien and began foreclosure proceedings a little over a year later. The Millers apparently offered to make payments over time to the HOA, but they unfortunately failed to appear and answer in the foreclosure action that the HOA commenced. The clerk of court ultimately referred the foreclosure to a master, which is essentially it's an equity judge in South Carolina. And this case gets into a little bit of the distinction between equitable claims and legal claims and things like that. I don't want to get bogged down too much in that, but just understand that at this point, the case has been referred to an equity judge. The Millers responded, filed an answer asserting counterclaims against the HOA, and also filed a motion asking the case be transferred away from the master to a circuit court where their legal claims against the HOA could be heard in front of a jury. The master didn't do that, refused to do that. So they were essentially at that point denied the jury trial that they requested. The Court of Appeals ultimately reversed the master's decision and held that the Millers were entitled to a jury trial in circuit court on their legal claims against the HOA. So track with me on this. This starts out as what appears to be a relatively straightforward HOA foreclosure. Now in South Carolina, it's more involved than it is in North Carolina because it's a judicial foreclosure down there. But still, it's not something that's going to ordinarily wind up in front of a jury. But this association found themselves initiating a foreclosure over what started as a $180 debt. And now all of a sudden we're in circuit court in front of a jury in a much larger case, and probably more than this association wanted to chew when they took that first bite. What's also interesting is this court quotes another decision that was decided in 2019, Windrose versus Hale, which is its own cautionary tale about foreclosures in South Carolina. And in particular on foreclosures that are initiated over relatively small sums that are owed. Remember in the case I just talked to you about, a Homestead case, the debt that started the whole thing off was $180. In Windrose, which is a South Carolina Supreme Court case, there was a $250 debt owed on a home with, I think, my notes here, a fair market value of $128,000. Those folks had $60,000 in equity in that property. And essentially it went to sale and the winning bid was $3,000. So you've got owners who owe this relatively small amount of money, have a ton of equity in the property, and then the winning bid is $3,000. And the Supreme Court in that case, I think, went a little bit out of its way to say that bid of $3,000 shocks the conscience of the court. That's the quote. That when you look at the totality of those circumstances there, small debt, home with a lot of equity, the court went out of its way to reverse that foreclosure. And we've got to be careful about how we interpret a case like that, because it doesn't establish a bright line rule that X number of dollars is either enough or not enough to proceed. What it does tell us, though, is that we have to be cautious and intentional about making a decision to proceed with a foreclosure, particularly when it is a relatively small sum that's owed. It's not something that you can just launch off into recklessly, because we've got examples here of at least two cases where that did not turn out the way that the HOA wanted. In Windrose, the whole thing was thrown out. And in Homestead, because of the way the owner decided to combat the association, this association is now going to be in circuit court in front of a jury defending itself against these legal claims that the owners have made in their own defense. So again, cautionary tales about South Carolina foreclosures. Tim, if you have anything that you want to add on those cases, please feel free to do so. But that's what I take away from those two.
No, I think it's summed up in just this slide on the takeaways here. We're talking about understanding that the South Carolina courts have made it very clear that they're sensitive to the abuse, what they deem to be the abusive use of foreclosure. And so there's some things you can do going out of your way to make sure owners are notified. Steve, you'll remember in the Windrose case, there was some evidence of the lawyers involved bragging about how many foreclosures they had filed, how many houses they had sold. And the court, frankly, was just offended by it. And so some special circumstances there. So by trying to do things the right way and thoughtfully, we put ourselves in the best position to be successful in those foreclosures. We're going to go back up to North Carolina, the Bearwalla Springs versus Lake Toxaway POA case. Bearwalla Springs at Lake Toxaway versus the community association up there. This is also a picture of Lake Toxaway. It's quite beautiful in the North Carolina mountains, but it's also old. There have been several cases involving Lake Toxaway, so they're old and they're litigious. But that's not there. There are some associations out there that are like that, and was governed. The Bearwalla relationship with the community association was governed by a developer site development agreement, which talks about the lots in Bearwalla and their obligation to pay to the declarant or the association. That's the community association. And that their funds that they pay are going to be used for a lot of different things, including the maintenance, improvement, lighting of common areas and facilities and recreation facilities during the development, which benefit the owners and the development. So we've got these two associations squaring off about whether who needs to pay whom what. Bearwalla saying we don't have to pay Lake Toxaway assessment. And if we do have to pay them, they've got to spend the money only on Bearwalla common elements. Now, Lake Toxaway said they do have to pay Lake Toxaway assessments, and we can spend the money only on Lake Toxaway common elements because that's what we're limited to doing. We have no authority to spend the money we collect on an adjacent community. So you can see these people are at loggerheads over this. And so we get decision number one. Yes, Bearwalla must pay Lake Toxaway assessments. They're entitled to use the portions of the lake, the areas within the Lake Toxaway Community Association, including the roads and facilities. The court found, and this is one of the things that's important to the North Carolina courts, that there was an ascertainable standard by which the court could determine the amount and the permitted purposes of those assessments, again, from the development agreement, and that the Bearwalla obligation was closely connected to the land in Bearwalla so that, the legal term is, it touches and concerns the land, so it runs with the land. And all that means is that it's going to be an obligation of anybody who buys property in Bearwalla going forward. So that's decision number one. Decision number two was that Lake Toxaway must use, quote, some portion of the assessments paid to maintain Bearwalla, because it talks about the maintenance improvement of lighting and common areas and facilities within the development. And the parties acknowledged the development, which was not defined in the agreement, again, need to be specific on these things, was Bearwalla. But it's not over, because they sent this case back to the trial court to determine just how much has to be spent on Bearwalla, keeping in mind that the Court of Appeals gave them the wonderful standard that you have to spend some portion. So there's going to be more fun in the trial court as we try and sort this out. So what are the takeaways from this case? Governing documents may legally obligate owners in a community to pay assessments or other charges to somebody outside the community if the obligation is clear and the expenses touch and concern the land. And this can get to be very expensive. One of the cases that we did not talk about today is Hedgepeth versus Smoky Mountain Country Club Clubhouse LLC, series of cases. And in that case, the association says, heck no, we're not paying the developer what is provided for in our documents, and then faced a $7 million judgment, which drove them into bankruptcy. Be very, very careful about ignoring those kinds of obligations. Steve, we've got, let's take a few minutes. We tried to move through a lot of material, but we do want to talk about corporate rentals and those concerns.
This is a huge issue. I know if I look at my inbox right now at this very moment, I have 3 new requests coming in with concerns over corporate rentals and what our clients can do about it. Just this week. I know that I am not alone in that, and that Bob and Cynthia, who are involved in that on a daily basis, have just as much volume and similar questions coming in. This is a tremendous issue. It's gotten a lot of traction in local media, where you may have read or seen things on this. The reality is that housing patterns in this market are changing nationally. I think, and this is anecdotal, that while what we're talking about here, the influx of corporate rentals, is a national issue, I think it's heightened here in Charlotte. I think it's heightened here in Charlotte because of the number of people we have that are moving to this area. Whether you're north or south of the border, if you're in the greater Charlotte area, I think you know what I'm referring to. The stats that we have right now are that corporate landlords right now own 13,600 homes in Mecklenburg County. 93.5% of homes purchased by corporations were for $300,000 or less, which means that depending on where your association falls in terms of sort of mean or average price point, that's going to dictate whether you're probably being impacted to a greater or lesser degree by corporate rentals. We have some clients that find themselves in that, it's wrong to call it a sweet spot, it's in that danger zone of being right around $300,000, $250,000, $300,000. That's that's the prime target for these large corporate buyers that are coming in, and very often they're buying with cash, and they're buying with cash as soon as a property hits the market, and sometimes before. More than 1/3 of Charlotte homes that were sold in the last quarter of 2021 were purchased by these corporate investors, and blows me away. 6 corporations purchased most of them for cash. 6 corporations did most of that buying in the last quarter. Why is this a concern? Number one, it does obviously reduce, if not eliminate entirely, affordable starter homes for folks who are in their 20s, 30s, wherever, trying to buy that first property. An individual purchaser in this market, with corporate rental outfits being as aggressive as they are with cash offers, cannot compete. Obviously promotes rent inflation. Demand continues to increase for a very limited supply. That's basic economics. And then for what's really a concern for most of our clients is the fact that corporate landlords don't appear to care very much about taking care of their properties, whether it's aesthetically or making sure that their tenants are otherwise complying with restrictions and so forth, like an individual owner or occupant would. And then there's also obviously the fear that a high percentage of rentals in a community, regardless of whether it's owners are corporate outfits or smaller, either individuals or something that doesn't rise to the level of an American Homes for Rent or something like that. Just a raw percentage of rentals, if it gets too high, can depress property values, and that's just a real concern for our clients. So what can you do about that? When the concern is corporate investors, and I actually shouldn't limit it just to corporate, but to an investment purchaser, regardless of their size. One of the best things that you can do is pursue and make the case for an effective amendment to your restrictions. I'm talking about your declaration, not your rules, not your bylaws. I'm talking about your declaration, or in South Carolina, your master deed, to essentially disincentivize this investment purchase. One of the ways that I know we're doing that here at the firm is to try and steer clients toward establishing a mandatory waiting period after a property is purchased, where you've got to wait 12 months or some defined period of time before a property can be leased. The idea there is that merely having that waiting period restriction on the books in your community is going to make your community less desirable to an investor, because it immediately frustrates their entire purpose for purchasing property. They're not buying it to live there. They're buying it to immediately lease it and start making money off of it. If we can get a valid restriction in place that forces them to wait 12 months, they're probably not going to do that. They're probably going to choose to buy somewhere else, go down the street to another community that doesn't have that kind of a restriction in place. And that's, we're steering a lot of our clients in that direction. We think that is an effective deterrent. The anecdotal information that we get from being in communication with managers is that very often they get contacted by prospective purchasers, prospective investors, and they ask outright, is there a leasing restriction in place? And those communities that are in a position to say, yes, there is, and if you purchase, you'll have to wait 12 months or whatever it is before you can lease your property. That's enough. In many cases, we're finding to send them on down the road somewhere else. Now, how that's going to play out as more and more communities are getting these restrictions in place, I don't know. I am not aware of a restriction like that. And Tim, please interject if you are. I am not aware of a restriction like that being challenged legally in any reported case that I've read. I think the likelihood that that will occur in the future is high. Can't say when, but I do think that as more and more associations are taking proactive steps to change their restrictions and to discourage this sort of purchase, there's just too much money in it for somebody not to challenge it eventually. So I think that's going to happen. It'll be interesting to see how that plays out. With that in mind, I had this conversation today with a client who wanted to say, well, let's do a waiting period. Let's do 24 or 36 months, something really, really long. In talking to that client, and I would encourage you, if you're considering the same with your board of directors, when you're looking at an amendment like the one that we're discussing here, do as little as you can to achieve the objective. The objective is to be a deterrent, is to deter the investor and get them to go somewhere else. If you can do that with a 12-month waiting period versus 24-month waiting period, I'm always going to encourage you to do 12, because it's much easier, I think, when that challenge eventually comes, for us to get up in front of a judge and say, we didn't go 2 years or 3 years and require people to wait that long. We said we had 12 months. We didn't push the envelope in what we could get approved. And I think that puts you in a better position if you happen to be the association that ends up being challenged, or if this thing gets challenged and we get a decision that ultimately says a 24-month waiting period is too long. If that were to occur, you don't want to be one of the associations that has a 24-month waiting period. So that's I want to make sure that we got time for questions, but that's really how we're trying to attack this problem. It is a real problem. You do need to be careful about the language that you use in your amendment. Make sure that it's reasonable, make sure that it's clear. And again, I harp on this all the time. Do as little as you can to achieve the objective. That applies not only to an amendment related to rentals like this, but in my opinion, amendments across the board. We want to approach amendments with a scalpel and not with a hand grenade, and be surgical with what we're doing. So we will transition to questions here, I think, for at least a few minutes. Thank you all for being with us today. We look forward to answering a couple of your questions.
Yeah, we are at 5:30. We were trying to make it in 50 minutes, and we had just too much to share with you this year. Sometimes we in some years we're over in 20 minutes, but a lot going on in both states this year. You will see there is a reassurance here that no alcoholic beverages have actually been consumed during this presentation, so the information you've gotten is accurate and reliable. But we do want to take some questions, and Steve and I are gonna hang around. We won't be offended if folks break off at 5:30. If you need to do that, please feel free to do that. Our feelings won't be hurt. But we're going to be around for some minutes to answer questions that have been sent in. And I'm going to stop sharing this screen. And Kathy, you're going to help us if we have some questions, I think.
And we do have a few questions, so thank you very much. And for those of you that do have to, I just want to remind everyone that this webinar and all of our monthly webinars, which are the third Thursday at 4:30, you can find on the CAMS website, camsmgt.com. So if you do have to go, perhaps you can hop on and enjoy the questions that we have. We have a few.
Okay.
And the first one comes back to the topic you covered in one of the cases two of the cases, actually, free use of the property. An owner in North Carolina states their declaration says owners of new units pay a one-time fee into the reserves at closings, and they would like to change that to new and existing units paying that fee at closing. And they're asking, is this hard to change in North Carolina?
It's impossible to change in North Carolina. The reason is, sorry, Steve, I just jumped right in there with that. In North Carolina, there's a difference between North and South Carolina on this very issue. In North Carolina, it's called a transfer fee. There is a statute that was enacted 2010, I believe, to prohibit those, but to accept a one-time transfer fee to when the property is transferred to what's called the original transferee. So that's once. And so if we're talking about amending it to doing it on an ongoing basis, that's prohibited by the statute. You can't do that in North Carolina. However, just South Carolina, folks, South Carolina statute reads differently. And it talks about transfer fees that are payable to an association that don't go back to the declarant or a developer are permissible. So you can have recurring capital contributions or transfer fees in a South Carolina community as long as it doesn't benefit the developer. There were some documents across the nation, frankly, that where developers were creating annuities for themselves from the associations they created, and the legislatures and various states said no. North Carolina, South Carolina did it differently. Steve, any comments on that?
Nope, that's it. It's chapter 39A if you want to read it in North Carolina.
Thank you.
Thank you very much. So the next question is about solar collectors. Have you heard anything about allowing HOAs to qualify for grants to offset the cost of installing solar panels on amenities?
I have not had any association loop me in on that effort to qualify for those grants. I have not.
I'm not aware of any either. Thank you. Appreciate that. Our next question deals with that foreclosure on a small fee.
Small amount.
Would a few $1,000s be considered a small debt for foreclosure, or do you have any idea what that threshold is?
I mean, the cases that we looked at, you're looking at just a couple of $100s in each of those cases that we have to draw on here. I mean, a few $1,000s, I think is almost certainly enough to act on. I mean, I would feel comfortable saying that our firm does that all the time. You also need to look, I think, at, the interval that those installments are being levied and then missed. I mean, if you've got, I could see an argument that even when the raw sum is somewhat low, if it's an entire year's worth of assessments, I think you can make an argument that that should be actionable. Those cases that we pointed out had a lot of other facts on them. We couldn't get into all of them today. But one of the things that you need to be aware of is looking at, and Tim, jump in here if you want on this as well. One of the things you need to be looking at are the facts that those courts looked at. How much equity is in the home? Is a home owned free and clear and we're going to foreclose on it for $400? I mean, you may run into a court that just doesn't like those facts, but we don't have a bright line, above this threshold, you're good, below this threshold, you're not. But the question about a few thousand, I would not hesitate to lean and foreclose over that amount.
No, not at all. And you're right. It's the totality of the circumstances. If you have a community that has relatively low assessments to where that over a course of 2 years, you have people who owe $450, $500, $250 a year because they're street lights and some other things and some limited common areas. And you have 200 people in that community and 100 of them are not paying. That has a tremendous impact. And what we need to be in a position to do is to tell Judge Weaver in York or the special referee in Lancaster, which is where we end up most of the time because most of our South Carolina clients are in those two counties. Look, Judge, this is why this is an impact. This is why we're here on a small amount. In isolation, it looks significant. But this community has been devastated because there's been a pervasive failure to pay. Just being able to make those explanations and to show that we did everything possible to give these folks an opportunity to pay, went out of our way, and we were stonewalled. That was not the case in at least the Winrose case, because those facts were terrible. So we can't draw that bright line. We're just urging you to be sensitive to the court's perspective and have an explanation of why we did what we did and why we did it this way. And we want to cooperate with you in that and be able to give those explanations, because we're the ones that are going to be standing in front of the judge trying to explain why we're here. And just words to wise.
Thank you very much. Our next question is, if a renter breaks the HOA rules, do we notify the renter, the owner, or both? And so we know the answer to that, right? But what if a unit is owned by a trust? Do we notify the occupant, the trust attorney, both?
Well, a trust, property that's held in a trust, I was actually looking at something similar to this today. It's owned by a person. It's owned by a person in a capacity as trustee, but there is a person there to notify, and that's who you would notify. I think we all would agree that from an enforcement perspective, when somebody's violating a restriction, the party that we've really got our hooks in is the owner. So, I would say if you've got a tenant that's causing a problem, I would encourage notifying them both. I mean, send the notice to both and not make an either or decision on that. The trust issue actually isn't as complicated as it may seem. If you think of it as being owned by a person in a capacity as trustee for a trust.
Great, thank you. We have a question about the corporate ownership, and I actually have one too. So if an association wants to have an amendment to their declaration to initiate that waiting period you talked about, a 12-month waiting period. Let's assume a supermajority is needed to pass that amendment to the declaration. What if 70% of the owners agree to the amendment? Is it still enforceable against the 30% who didn't agree?
If it's validly adopted, I mean, we're assuming that the 70% that you mentioned in that example is enough to clear the threshold for the amendment. If it is, then yes, there is case law. I know of some very specific case law in the context of condominium. I don't think the principle would be any different in the planned community, but it is effective against not only those who voted for it, but those who are subject to the declaration that's been amended.
Great, thank you.
One quick caveat to that regarding amendments generally, not necessarily in the context of corporate rentals. There is case law in North Carolina that's direct on this point, and in South Carolina it's indirect. That there are some types of amendments that seek to change something that was so fundamental in the community that even if you cross your T's and dot your I's, they may be found to be against public policy. There are a couple of cases, the Wallach case and the Armstrong versus Ledges case, where they crossed the T's and dot the I's, but still found that the amendments were so significant and changed people's expectations to such a degree that the court wasn't going to let it happen. So we have to put that warning in that just because you get the right number, there are still maybe issues you need to think about as far as pursuing an amendment and what you may still expect once it gets passed. Sorry to interrupt, Kathy.
That's heightened even more in South Carolina, where we've got case law where if you don't have an existing, let's say an existing rental restriction in your declaration, you can't amend now to add a new one. That's a South Carolina specific point that I'm making.
That's the Erks case.
Valid point. That's we've had clients that have run into that before and have gotten pretty bad news from us that their options are severely limited because it just wasn't at all contemplated in their declaration, and we couldn't make any kind of a good faith argument that we're amending something that already existed, something that's already there. We're just adding something completely new, and in South Carolina, that's a no-go.
Thank you. Someone asked, are there other tools besides amendment to discourage corporate owners?
I mean, an amendment of some sort is certainly the best way to go, because that's going to be changing the document that includes all the restrictions on the land that are relevant and enforceable. So, which route you go with that amendment. I think there's some flexibility there. We get requests for rental caps, like let's just say only 5 rentals or only 10% or whatever. I'll tell you, I favor the waiting period personally, because I find that rental caps, and this is again just what I've learned from talking to managers along over the years, rental caps can be very, very hard to administer, to track, administer, keep a waiting list running. They can just be a nightmare. And the waiting period is sort of that scalpel approach to make your property less attractive to the corporate investors by undermining essentially their entire motivation for purchasing. I think it's the best one that I think I've found at this point. So you may think that, but
Nope, agreed.
Yeah. And from where I sit, I think somebody has to manage that rental cap, right?
somebody
Yeah.
looking at you, Kathy.
Something like that can be extremely labor intensive. It's amazing. So thank you for that. The next question. Some townhome communities enforce standards for painting, roofing, garage doors, landscaping, which control the aesthetics of the community. Can corporate rentals derail the standards?
I think I understand what the question is. I'm going to answer it, and if I'm not, then I trust the person will retype something else. The way that I would approach that question is to say this. Exterior maintenance, for example, is a tricky situation in a lot of instances, because we often find that the restrictions that talk about an owner's responsibility to maintain the exterior of their property in a good and sightly condition or something like that are essentially unenforceable, regardless of whether we're talking about an individual owner or we're talking about a corporate investor owner. The answer to the question is basically a corporate investor owner is an owner. To the extent that any owner is subject to an enforceable restriction that requires them to maintain their property to a certain standard, it applies to them as well. The problem that you run into is very often those maintenance standards that exist in declarations aren't a whole lot of good for anybody, or they're major gaps. And that would be my concern. They don't get a pass because they're not living there. They're subject to restrictions to the same extent as any other owner would be.
Just one additional comment on that. That's why for the last several years, we have done multiple amendments and in new documents put in a specific community-wide standard and the ability to adopt those standards so that you can have objectively enforceable standards that you can say, well, clearly this is not subjective. It's a nuisance, it's unsightly, but it's objective, and that puts you in a much better position.
What we're trying to do with that is to get beyond a subjective argument over whether this particular condition is attractive or sightly, because what's attractive to me may be very different than what's attractive to Kathy or Tim or anybody else who's on the conference with us right now. And our courts have been very clear that sort of ambiguity or lack of a clear and objective standard is a recipe for a restriction that is not going to be enforced.
So a question on that topic is, if your association documents do not have a specific community standard and you want to develop one, how tall your grass can be, that's something we always have thrown at us, right? Or what is specific nuisances? In South Carolina, if you develop a community-wide standard, would that need to be recorded with the county to be enforceable?
Yes. Yeah,
Certainly the right to create the community-wide standard, that power and some of the provisions have to be established on the record. There are times where community-wide standards are adopted and the document says they do not need to be recorded, but the best practice is to do that and simply provide that the board can amend them, and then they can be changed quickly, but still there's a matter of public record. Steve may disagree with that. He's looking like he has a concern.
Well, just a point that I would clarify because of the South Carolina Act. I would be concerned about having a community-wide standard that wasn't recorded in South Carolina.
That's true. That is very true.
the HOA Act that was passed a couple of years back.
Doesn't say anything about community-wide
No.
standards or architectural standards, but it does talk about bylaws and rules and regulations. So it's trying to get to things that we think are enforceable. So it is true in South Carolina, we do say anything that you want to enforce,
Yeah.
be sure it's on the public
If it's
record.
important enough and you want to be able to point to it in a notice of violation or something like that in South Carolina, the position that I think we're consistently taking is get that recorded
That's true.
in South Carolina.
And I'll put a plug in for attorneys. The reason you would want your attorney to be involved in developing that community-wide standard is one sentence can make the world of difference. Like you said, Tim, the board having the authority to amend that community-wide standard.
Mhm.
It's a little sentence that means a world of difference when
Yes,
it
it
needs
does.
to be changed. The next question. Do you want to talk about Facebook any today? That's our next one.
Okay.
How do you deal with a hostile board member who's using their personal Facebook page to publish misinformation regarding board activities? And that misinformation has resulted in threatened litigation. And this is a North Carolina association.
There are three things that come to mind for me. Number one is, as a general rule, regardless of how it's getting out there, the best way to combat misinformation is with good information clearly communicated. I think if you've got somebody out there who's using Facebook or any other platform to spread things that are lies or misleading or whatever, it may be worth sitting down maybe with the assistance of counsel, maybe with assistance from your property manager to say, we are aware that X, Y, and Z has been said. Here's the truth. And put it out there. Because I think what you find is that in doing that, well, let me say it this way. The person that's on Facebook spreading a bunch of misinformation and so forth may seem like they have a huge audience or that they're causing a lot of disruption. Very, very often, and I'm thinking in nearly every instance that I've been looped in on that sort of has that flavor to it, the folks who are making all the noise are mostly just annoying 95% of your community, and they don't have their ear. Nobody's listening to them anyway. So I think to the extent that bad information is being disseminated, get good information out. As far as what you do about the board member that's doing this, a couple of different options there. Your board very likely has the authority to remove that person, not from the board itself, but from any officer role that they hold. If this happens to be a vice president, an appointed vice president of the association, the board can probably on its own, by vote or probably not by resolution because it won't be unanimous, but by vote, remove that person from their office so they're no longer vice president. And then if it's bad enough, you might put that person up in front of the membership and say, look, this person is spreading lies. They're doing this, they're doing that. They need to be removed from the board, and we're going to ask the membership to vote them off the board. I've seen it come to that before. Sometimes it does. It's not pleasant, but sometimes that's the only option.
But it's far better than the board, all of the good board members resigning and leaving the fox in charge of the hen house.
I've seen that. And there's one association in particular, not a CAMS association, but one that I was involved in. And the entire board abdicated and just let this, they resign, let this one guy take over. And he had a 2-year period where he fired us, fired the management company, did whatever he wanted, and he ended up embezzling a bunch of money. I mean, it was just a disaster because it was literally fox in the hen house. So Tim's exactly right. The option of going through the unpleasantness of a removal vote is far preferable to that.
Yes. Thank you very much. In South Carolina and in a private gated community, will DMV laws that apply to private property extend to community property?
I'm not sure I understand that question.
It said it's related to the use of UTVs and dirt bikes operated by underage drivers.
I wouldn't know how to answer that without researching it. Tim, what do you think?
I think your caution is appropriate, but what I sort of hear is, do the state laws apply inside? If the question is, do the state laws apply inside a private community that does not have public streets, and it's just private ways that are owned by the association, administered by the associations, do Do the speed limits apply? Do the regulations of those types of vehicles? I'd want to be sure, because we always want to look and be sure. There have been a number of times where I thought I remembered things correctly, but I didn't. But my subject to that qualifier, usually when you get inside private property, the real problem is that we don't have state laws that apply. So how do you deal with speeding? How do you deal with vehicles like that? And you go back to your documents, and do they appropriately regulate those kinds of things? And we have drafted those kinds of things for North Carolina and South Carolina communities so that it is clear. And we're not simply relying on state laws, because law enforcement doesn't come in to enforce those kinds of things, or DMV or any other governmental agency. So it is a different world when you get inside a private community, and gated generally means private and private roads.
And that's an important piece of information, is will the law enforcement personnel come into the gated community? I've managed associations where they will. A municipal law enforcement agency will come in and enforce speeding or anything else, and many of them they will not. So.
Sometimes there's hoops that you have to jump through.
Yes, that's true.
Or county or municipality, get a certain form filled out and oftentimes recorded, giving them authority to act. It takes all sorts of different forms.
Jump through those hoops. It is 8 till 6. Do y'all have a few more minutes? We have 4 more questions at this point in time.
I'm good. And we can listen to those. I have one more thing to share before we end. That'll only take a few seconds. So let's wrestle with those questions. I'm okay, Stan.
Okay, and we do have a number of people still on the call. So let's.
Well, thanks for staying with us. Thanks for staying with us.
They're getting some good information. Our condo bylaws state that no apartment shall be used for commercial activities of any character. Does this potentially apply to companies buying units for the purpose of renting them in South Carolina?
Yeah, the reference to the word apartment tees it off. That's a South Carolina condominium under the Horizontal Property Act. Nobody in North Carolina calls a condominium an apartment, so we know where we're coming from here. This whole issue of whether a residential use restriction is going to prohibit rentals is being debated all across the country. And there are some cases that find maybe so. I think my view is that the trend is that no, it does not, because a rental use is a residential use. It's just a different type of ownership structure. And again, when we're talking about strict construction, well, if we can find a way to not make it apply, and it's subject to those kinds of interpretations, we have to take the one that's the least restrictive. Steve, what do you think about that?
No, I agree that there is and I'm racking my brain trying to remember the details, but I'd have to go and research it. There is a case in either North or South Carolina that says, no, that is not a commercial use. I don't remember which state it was without going back and looking, but there is a case in one.
I think it's North Carolina, but I'm not sure.
And I think just from a legal analysis perspective, I think the right result, the legally correct result, should be that whether I'm leasing it or I'm buying it, if I'm eating there, sleeping there, hanging out with my friends and family there, that's residential purposes. It's residential use, regardless of the form of ownership.
Thank you very much. So this corporate rentals is a big topic. We're getting lots of questions about that. Here's another one. A covenant prohibiting rental within 1 year of purchase in South Carolina. Would it be enforced through injunctive relief in absence of any penalty provision in the covenants?
Certainly could be. The way that you would enforce that, one of the ways that you would enforce it is to file a lawsuit asking a court to enforce it through an injunction, compelling the new owner not to lease the property for the duration. I think that's certainly an option.
Yes, I absolutely agree with that. Brings up the need for carefully drafting the amendment to restrict it to 1 year to also include a provision that if that period is violated, the 1 year period starts again. In other words, you can't violate it for 6 months and then say, okay, court, if you keep us from doing this, or 9 months because it takes so long to get through the court system, we've already passed the 1 year. We get to do it now. No, be careful how it's drafted, which is why we encourage you to work with us on it. We include that so that that period is what's called tolled if it's violated, and you still get the 1 year.
Thank you very much. So here's another one on capital contribution. Our CC&Rs state at closing a certain amount of dollars are to be put in the capital fund. Which fund shall be used for unforeseen future expenditures? Currently, that money is being directed to operations. Is that legal? So it says at closing.
I'd want to read a heck of a lot more out of that document before I touch the is that legal or not question.
Okay.
Tim, what do you think about
All
that?
I can say is that the words that Kathy read to us are pretty broad and general as far as the standard. And if someone's arguing that this should go into a capital improvement fund, I mean, the whole idea of unforeseen expenses, well, okay, we didn't count on that, is a hard standard just on that language to apply, but we need to look carefully at the rest, Steve says, of the rest of the document to see, again, what the intent was, or what we can glean was the intent from that. And sometimes there are provisions not in the declaration, but maybe over in the bylaws about that particular amount that's collected.
Sounds good. Let's see. In South Carolina, a condo's master deed states the HOA Board of Directors may from time to time make rules restricting the length of time short-term rentals are allowed. For example, certain buildings units cannot be rented for 7 days or less, or 3 months or less. Is that okay? Can an HOA board?
I'm not sure that I understand the question. I mean, if the master deed is giving the board the authority to, by rule, establish a minimum lease term,
Can it be applied to certain buildings, units?
okay,
Not the
but not to
entire.
all.
Not to all.
That's how I'm reading it.
No.
For example, certain buildings units can be rented for 7 days or less, or 3 months or less.
Gosh, I would have a real hard time getting comfortable with treating the owners in building A different than the owners in building B. If that's what it's getting at.
Well, you clearly have the authority to establish it by rule. Notwithstanding that fact, we frequently recommend folks pursue an amendment because that locks it down. We're not going to get into fights before a court about whether that's within the authority.
Right.
But anything that says the board's going to single out a building or these units as opposed to these units, that really doesn't pass the sniff test. And a lot of court decisions are based as much upon what smells bad as what is bad. So I'd be very, very leery of that kind of an approach.
Yeah.
Thank you. Last question. Can condo owners install outside cameras as long as the view the cameras have are of areas where people do not have a reasonable expectation of privacy?
Well, if it's a condo and the fact that it's outside, that indicates to me that camera's probably hanging off the common elements
Yes, it is.
somewhere. So I would not say, yes, they have the right to do that. I don't think they do have an objective right to do that. I think the question becomes, are we as the condo association going to permit that under certain circumstances? And you might. There's certainly steps that you would want to take because that camera is going to be impacting the common elements. If you were to allow that person to install the camera there, but I don't think they're going to have a right to install it in the common elements. Tim, what do you think?
Agree 100%. But the other side of it that we have to balance in this, and there's almost always a balancing that goes on, is if we're not talking about, a camera mounted up here and shining out at various places, suppose we're talking about a Ring doorbell. Somebody says, I would like a Ring doorbell on because of the security. I want to know who's coming to my home. And does the condominium association control that? I think arguably they do. It's going on the common elements. But and do you just arbitrarily say no cameras? Well, then you have the safety and security situation. And I think that bears some thought as to whether the association says, we are going to permit those kinds of things because we do think it enhances security of the entire community. Because goodness gracious, how many newscasts do we see where we're getting video from the I'm not supporting Ring here, but from doorbell cameras that verifies who walked by, who did this. So it's not something that like many other things, we're not going to encourage our clients to just arbitrarily say no, no way, no how. Think about what the implications are. They may go beyond purely aesthetics, and some cameras may be just fine and in fact desirable.
And the last bit of that, I think, though, is if you're going to allow a camera like that in the common elements that the association would otherwise be responsible for, I think it bears taking some affirmative steps on the front end to get an agreement in place whereby the unit owner who's going to get the benefit of being able to install this camera accepts in writing responsibility for installing that thing, maintaining that thing, removing it if it's got to be removed, indemnifying the association for any losses that arise because the installation impacts the common elements in a certain way. We've put together agreements like that before under those same kind of circumstances. But you want to do that on the front end when the person asks for permission, if you're inclined to give it. Take care of that on the front end.
Thank you. And the other piece is, if you allow one owner to do it, are you obligated to allow any owner that asks for it?
Yeah, you need to be uniform in the application of those particular decisions.
I agree. Well, Tim and Steve, thank you so much. Very informative, a lot of helpful information. We certainly do appreciate it.
Kathy, I got one thing.
You had one more thing?
I got one more thing I want to do. I want to go back and can you see my screen there? You remember these people here? I want you to know what the answer is. Well, the answer actually is none of the above, because these are board members who've just completed Ask the Expert or the CAMS Summer Law Seminar and are now confident that they're much better educated and equipped to serve their communities. And so that's the answer. We thank you for the creative suggestions that were made about what was happening here at this particular situation. And Steve and I appreciate the opportunity to be with you. Thank you to those who hung with us for this long. We hope it's been helpful.
Thank you again. And a reminder, you can find this webinar and others at camsmgt.com. Thank you so much, and we'll see you next month, third Thursday at 4:30.
Okay. Bye, everybody.
Thank you, guys.